matter of people against Matthew Gallagher under indictment 25035. We adjourn this matter to today's date for argument and decision with respect to the defendant's omnibus motions. The court is in receipt of the defendant's written motions, now along with the people's written response. Did either side wish to be heard any further? Mr. Littlebrain?
I do, Your Honor. Good morning. Just by way of introduction, Your Honor, this is a very dangerous case for Mr. Gallagher, who didn't strike anybody, because he gets caught up in the indictment and in the process of the people with whom he was grouped. Matthew Gallagher's body camera was on and recorded his every movement. The recordings show that he did not hit, strike, or harm Mr. Brooks. He did not touch his neck or hit his head at all. Notwithstanding, Mr. Gallagher was indicted for the same top two charges, murder in the second degree and manslaughter in the first degree, as others who allegedly kicked and hit Mr. Brooks when he first arrived at Marcy. Mr. Gallagher was not present for that. Who pepper sprayed and hit Mr. Brooks repeatedly in the hallway area. Mr. Gallagher was not present for that. And then hit Mr. Brooks in the head and pulled his neck in the infirmary room. During the infirmary time, body-worn cameras show that Mr. Gallagher was mostly out of the room and in the hallway, then out of the building at his assigned van in the parking lot retrieving leg shackles. His contact with Mr. Brooks was to move him up on the medical gurney from a partially standing position and then applying shackles to his ankles as directed, which is a doc's daily responsibility. So we get to Mr. Gallagher being indicted for murder 2 and manslaughter 1, and this applies to the gang assault as well, along with those that struck Mr. Brooks based upon perjured testimony of Sergeant Trombley. He testified pursuant to a plea agreement. Once in the grand jury, he presented false testimony in direct contradiction to the recorded body-worn cameras of everyone in that room. There was indisputably false testimony before the grand jury and improper grand jury instructions, and now Mr. Gallagher stands indicted. First is factual. The special prosecutor elicited clearly false testimony. At page 234 of the grand jury testimony, Sergeant Trombley said, "I saw Officer Gallagher strike him twice." In that testimony, that's in the same flow of the questioning about the officers who in fact did strike Mr. Brooks repeatedly. The special prosecutor let the false testimony be part of the grand jury's decision when there are body-worn cameras by Mr. Gallagher, worn by him, and others that show that Trombley's grand jury testimony is false. The body-worn cameras show Matthew Gallagher the entire time and that he never hit Mr. Brooks, never. The special prosecutor knows we alleged it was false testimony because I raised the falsity in my motion. And I cited to that exhibit which we enclosed. And in response, the special prosecutor did not argue against that assertion at all. He did not point to anything on the body-worn cameras that contradicts what I just told Your Honor, or shows that Mr. Gallagher struck Mr. Brooks. If there was, the special prosecutor would have pointed it out to the court. The special prosecutor did not dispute the falsification of the grand jury testimony of Trombley, essentially conceding that Trombley falsely contributed the only facts about Matthew Gallagher that got him indicted, and in special relationship to the top two counts. Mr. Gallagher did not hit Mr. Brooks, and the testimony that he did is falsified. CPL 21-210.35 states that a grand jury proceeding is defective when the proceeding fails to conform to the requirements of Article 190 to such degree that the integrity thereof is impaired and prejudice to the defendant. This defendant, not every defendant, this defendant. When prejudice may result. May is in the statute. The Court of Appeal holds in People v. Thompson, 22 New York 3rd, 687, that, quote, due process imposes upon the prosecutor a duty of fair dealing to the accused and candor to the courts, thus requiring the prosecutor not only to seek convictions but also to seek justice is done. The prosecutor cannot provide an inaccurate and misleading answer to the grand jury's legitimate inquiry, nor can the prosecutor accept an indictment that he or she knows to be false, misleading, or legally insufficient evidence. In People v. Houston at 88 New York 2nd 400, the Court of Appeals held with respect to false testimony given at the grand jury that, quote, we have long condemned any grand jury practice that might incline a witness to give an inaccurate account of his knowledge of a crime. And Houston again said, Court of Appeals, quote, it is not necessary that there be actual prejudice. Dismissal may be appropriate based upon the facts and circumstances of the individual case where a defect created a possibility of prejudice. Here, special prosecutor had actual evidence that Gallagher did not strike Brooks. They had the tapes, they had the recordings. They had contemporaneous recordings, and they had Mr. Gallagher's recording, whose recording is the only one that portrayed most of that day. The only one. His body-worn camera and others never lost sight of him in the period of time whenever he was near Mr. Brooks. Yet, in a case, this case, where the cause of death was a beating, the special prosecutor presented his witness, a witness on a deal, on a plea deal, who testified that Gallagher struck the victim 2 times in the same flow of testimony of those that did strike Brooks. The prejudice to Gallagher is not a possibility. It is a certainty, and the indictment as against Gallagher has to be dismissed in order for these proceedings to have integrity, Your Honor. Second argument is the legal. And that leads us to what I believe was improper grand jury instructions. Mr. Gallagher is charged with failure to intervene as the basis for both the murder 2 and the manslaughter 1 charges. When we were here in court the second time, the special prosecutor presented to the courtroom a directive issued by Docs that was claimed to create a duty to intervene as the basis for the murder and manslaughter criminal liability charges for Mr. Gallagher, in which the special prosecutor claimed in court arose from a duty to intervene in the Docs directive. That's where the duty to intervene came from. According to the Appellate Division, People v. Myers, which is cited in my brief, criminal liability cannot be premised on a failure to act unless the party so charged has a legal duty to act. Where the alleged criminal conduct consists of the defendant's failure to act, which is here for Mr. Gallagher, the conduct is characterized as an omission as opposed to an act, which is defined in the penal law, section 15.00, as a failure to perform an act as to which a duty of performance is imposed by law. The Court of Appeals held long ago that there must be a statute to create criminal liability, to impose legal liability for someone's failure to act pursuant to that duty. Not a Docs directive, which is an employment directive. That cannot create such a duty in order to hold a person criminally responsible. The term imposed by law, as used in the penal law, refers only to a duty created by the statutes of the state of New York, and a defendant can only be charged and can only be convicted with failing to perform a duty when that duty is established by statute. There is no statutory duty for correction officers to intervene in the exercise of force of others in New York State that can be a basis for a criminal charge. It can be a basis for discipline. It can be a basis for civil liability. It cannot be a basis for a criminal charge. We can all say that there should be such a statute, but on the date of the incident, there was no such statute in this state which created criminal liability for a correction officer's failure to intervene. The state legislature realizes that and has introduced legislation in an attempt to create a duty to intervene. The last 3 sessions of the state legislature attempted to do so. And here's what the legislation summary says. This is from the legislatures. The legislation will enact Carryall's law, which mandates police officers or peace officers, the CO here, to safely intervene when such officer observes another officer using excessive force. Section 3 of that proposed law makes the failure to intervene a crime, creates the duty, creates the criminal consequences for failure to respond to that duty. That law doesn't exist today, and it didn't exist when this incident happened. The special prosecutor argues that this new law, quote, clarifies existing law. It does not. It creates a duty to intervene as a basis for criminal liability where none before existed. But that legislation remains pending, and until it's established or adopted, there is no statutory duty for a correction officer to intervene that can exist as a predicate to charge Mr. Gallagher with criminal liability to failure to intervene. The people's response in trying to find a duty is to present a collection of docs directives, which is employment directives, and unrelated laws to try and cobble together that there is a statutory duty to intervene. And that only goes to show there is no such duty. The duty they claimed here in court, when we were here several times ago, and which I believe the court will find in the grand jury charge, improper as it was to cite the docs directive, which is an employee manual document and not a law. In their arguments now, the people attempt to create a new duty upon Mr. Gallagher to arrest his co-defendants through a peace officer's power to make warrantless arrests under CPL 2.20, offered by the special prosecutor as an equivalent to a duty to intervene for which Gallagher was charged. That's in Mr. Hudson's brief at pages 3 to 4. I am of the belief, based upon the special prosecutor earlier making so pronounced a docs directive for a duty to intervene, that the grand jury was not charged with the duty to arrest that is now being argued by the special prosecutor, and upon which the grand jury would have to have deliberated on its decision to charge Mr. Gallagher. The duty to arrest, if one existed, and it does not, is not a duty to intervene, and is not a duty at all. The relevant provision, CPLR 140.25, states that, quote, a peace officer may arrest a person in certain circumstances, not shall or must, or any other word which denotes a mandate or requirement. It states a peace officer may arrest a person. The obligation to arrest of a peace officer, a CO, to make an arrest upon which the people base their new argument is entirely discretionary. The appellate division of the second department at Kesselman, which I cite in my brief, held that, quote, a decision to arrest an individual involves the exercise of discretion or expert judgment in a policy matter and thus is cloaked with governmental immunity. The people turned this discretionary arrest authority on its head by arguing that because Gallagher may make an arrest, that this required him, that it is a statutory duty upon which they base a criminal charge. The people's argument essentially states that if a peace officer or police officer, because they're both covered, fails to exercise statutory discretion to make an arrest inside or outside a prison, that officer will face criminal prosecution. That they have a duty to do so, but they would have failed. Their failure to do so results in criminal prosecution. That argument is wrong under the statute and the law, and if held to be true, comes with massive consequences across New York state law. This is not the case to identify that as a new duty. In further seeking to justify their argument that the court need not find a statutory duty, the court argues by analogy to a duty of care owed by parents to children, and argues that parents can be held criminally liable for failure to intervene in connection with their children, without, argues the special prosecutor, a statute so saying. The fundamental flaw in the people's argument is that such parental duty is grounded in statute. Section 1012 of the Family Court Act defines a neglected child as one whose physical, mental, or emotional condition has been impaired or is in imminent danger of becoming impaired as a result of the failure of his parent or the person legally responsible for his care to exercise a minimum degree of care. According to the Court of Appeals, a reading in Hofbauer, which I also cited, Your Honor, A reading of this statutory provision makes it clear that the legislature has imposed upon the parents of a child the non-delegable affirmative duty to provide their child with adequate medical care. And I emphasize what the Court of Appeals said. The legislature has imposed that duty. That is not an analogy case for the special prosecutor to argue that because a parent can be held criminally liable for mistreating their children, that's the same duty as a duty to intervene by a CO. For family court and the child protective issue, there is a statute. The Court of Appeals says there's a statute. Here with correction officers and peace officers, there is no statute creating a duty to intervene. Failure to fulfill the statutory duty is why parents can be held criminally liable for neglecting or omitting to provide a minimum degree of care to their children. By contrast, CPL 2.20, which grants peace officers, including COs, the discretionary power to make warrantless arrests, contains no language, like the Family Court Act, or any language from which a duty to intervene can be extrapolated. The people do not identify a statute that creates a duty to intervene. Without a duty to intervene imposed by statute, Mr. Gallagher cannot be held responsible for failure to intervene when he had no statutory duty to intervene. I stand on my brief for the rest of my arguments. I don't diminish them at all, Your Honor, but I want to focus on this argument. And we're requesting that the indictment, the 3 charges against Mr. Gallagher, murder in the 2nd degree, manslaughter in the 1st degree, and gang assault all be dismissed.
Mr. Hudson, did you want to be heard?
I would, Your Honor. Thank you.
Go ahead.
Before anything else, I think it's very important that everybody in this courtroom keep in mind the difference between something that's false and something that's mistaken. Mr. Lewebrand spent a lot of time talking about knowingly false testimony in front of the grand jury. There's nothing to support that whatsoever. This was one person's recollection of an incredibly chaotic event with somewhere in the order of 10 actors, all in the room, all doing different things, and certainly the 7 people who were charged with physically acting on Mr. Brooks. So to the extent that there's any argument that the people allowed knowingly false testimony to be presented, that argument goes well too far. We submit that witness's testimony was mistaken, but the grand jury had the video. They knew everything that Mr. Lewebrand pointed out for the same reasons that Mr. Lewebrand knows it. They saw what Mr. Gallagher did and didn't do. So the notion that some 2 nondescript punches somewhere in the long continuous thread of that witness's testimony about what everybody else in that room was doing to Robert Brooks would somehow sway the jury, and that would be the thing that convinces them that Mr. Gallagher needed to be charged. I don't think that argument deserves much weight. Instead, the evidence that we have against Mr. Gallagher that the grand jury did see for themselves and that we have relied on both in our brief and throughout this case and in the language of the indictment itself is that Mr. Gallagher, during a particularly brutal moment in the attack on Mr. Brooks, walked up to him while other officers were already pressing Mr. Brooks' head down, constricting his movement, and it's our position, certainly, that there's no apparent resistance or struggle on Mr. Brooks' part, nor is it possible, really, based on how he's positioned, that he's saying anything. Mr. Gallagher walks up to him, grabs Mr. Brooks by his shirt, and pushes him down onto the bed and holds him down, while another one of those officers takes his full body weight and punches Mr. Brooks in his groin twice. Mr. Gallagher keeps holding Mr. Brooks down until he leaves to go get leg shackles that he then applied to Mr. Brooks. Again, when the video shows that there's minimal action on Mr. Brooks' part at this point. And those leg shackles aren't just window dressing. They play a part. Another co-defendant stands on those leg shackles while Mr. Brooks is punched, and the multiple minutes that it took to get those shackles off Mr. Brooks while he was being pressed into a corner of that emergency room were critical because Mr. Brooks was alert before he got pressed into that corner. And he showed no signs of consciousness ever again after he left. So as far as the actual conduct of Mr. Gallagher by itself, based on being in the room for as much of the attack as he was, and that includes seeing Mr. Brooks being punched in the face, being choked, being lifted off the table, to then jump into that fray, hold Mr. Brooks down while he continues to be beaten, and then to additionally contribute to what appears to be the fatal exchange. That's significant. And to do those things, knowing what was going on, we submit does demonstrate depraved indifference. Now, turning then to the duty to intervene, ultimately, the duty between parents and children, that is beyond any argument, that exists. There's a criminal responsibility for a parent to take care of their child. That comes from the definition of a neglected child. That's it. There's no, you shall be held criminally liable for. There's no, if you don't do this, there's that. There's a family law statute that says this is a neglected child. It's a child whose parent or somebody acting in loco parentis does not meet these requisite standards. That's it. And from that, the Court of Appeals said, okay, that's enough. There's a criminal duty of care between parents and children. It's not hard to see why. Children entirely depend on their parents for everything, food, having a roof over their head. Mr. Brooks depended on Mr. Gallagher and the other corrections officers as well. So when we've got a statute that provides correction officers like Mr. Gallagher with powers, including a power to arrest, and I want to clarify that point as well, Your Honor, we're not relying on a duty to arrest. We're talking about the interaction between powers being vested in correction officers, but having those powers depends explicitly by the statute on their acting under their duties based on their place of employment. The power to arrest is how we get from a DOC's directive that it mandates that correction officers intervene when there's a use of force to a legal principle establishing that they do, yes, legally have a duty in a situation like this where an incarcerated individual is entirely dependent on them for their every daily need to stop other people from engaging in conduct that is this plainly reprehensible. Now, given that, we've got a statute vesting them with powers. That statute ties to DOC's directives. DOC's directives say you have to intervene when you see this. We submit that that is a statutory authority for a duty to intervene. Your Honor, other than that, I believe that addresses most of Mr. Brewerbrandt's verbal arguments today. And if there's anything else the court would like us to answer, we'd be happy to, but we'll rest on our papers for the most part otherwise.
Very good. Thank you, Mr. Hudson. Mr. Brewerbrand, a statement apparently having been given to law enforcement in this case by your client. Were you seeking on the hearing?
Yes, sir. At this point, yes.
All right, very good. Then as to the defendant's motion for Sandoval and Benedict hearings, that motion is granted and any such information must be turned over to the defense no later than 15 days before the first scheduled trial date. As to the defendant's motion to review the grand jury minutes in this case, that motion is granted. The court will review those minutes in camera for sufficiency, including the legal instructions given, and the court will pay particular attention to the arguments advanced by counsel here this morning. The court will also order a Huntley hearing be held in the matter concerning the voluntariness of statements the defendant allegedly made to law enforcement. In terms of the scheduling of that suppression hearing, Mr. Brewerbrand, my first availability would be July 15th, 16th. I also have the 18th.
The 16th for now, good?
16th. So that'll be at 10:30 a.m. Gallagher, that's when I next need you back here in this courtroom, July 16th, 10:30 in the morning. We'll have a suppression hearing and then we can move on to talk about scheduling your trial. I'll see everyone back here then.
Oh, wait. Sorry, Your Honor, one more thing for the record. We have just provided another thumb drive. We received another package from the state troopers on Friday. For the most part, it's nothing new. It contains another copy of the axon extractions, so those have been provided to defense counsel previously, but we figured we'd provide everything again as the troopers have provided it to us as well.
You proceed the same, Mr. Lewis.
I acknowledge that received with thumb drive.
All right, very good, thank you. I'll see you all back July 16th.
Keifer.
This is the matter of the people against Nicholas Keifer, indicted 25035. This matter was adjourned to today's date for argument and decision with respect to the defendant's omnibus motions. The court is in receipt of the defendant's written motions, now also along with the people's written response. If either side wishes to be heard any further, Mr. Longretta.
If I could briefly, Your Honor. Thank you, Judge. Your Honor, the evidence before the grand jury, as it relates to the conduct of Nicholas Keifer, is insufficient to support the charges of murder second, depraved indifference, manslaughter first, intent to cause a serious injury that results in death, and or gang assault. With respect to murder second, depraved indifference, Judge, there must be a showing of conduct that evinces an utter and total disregard for human life. If the court takes a look at the testimony had throughout the grand jury proceeding, and they credit the prosecution with the testimony that's in the grand jury proceeding, it still will not reach to the level of a depraved indifference, evincing an utter disregard for human life. Your Honor, the theory and the claim of the prosecution is that this is a continuous assault that takes place at the Marcy Correctional Facility at 3 different locations. The first location is in what they call the administration building, right in front of the arsenal section of that building. The second one takes place on a walkway going from the administration building to the infirmary. And then the third, which per Mr. Hudson, admittedly is where the blows were delivered that resulted in the death, took place in the infirmary in that treatment room. Per the people's own opposition to the motion, Mr. Keifer was ordered out of that room, so he is not involved with any conduct or contact with Mr. Brooks while in the treatment room. That then leaves the court to consider the conduct of Mr. Keifer in the administration building by the arsenal room. You go through a salary court, you go through a breezeway, then you could actually enter the facility. The grand jury testimony by the people's own witness who received a deal in this matter already, Mr. Kessler, he testified that there were strikes that were delivered by the COs while Mr. Brooks was in that area. He also testified, Judge, that that entire transaction within the administration building lasted between 5 to 7 seconds, and that's contained right within the grand jury minutes, Your Honor. Also within the grand jury minutes, Judge, there is the investigator, Jeremy Nash, who interviewed Mr. Keifer at the State Police Barracks and questioned him about that. Actually, it was Mr. Keifer that offered that. And he said, yes, I did strike Mr. Brooks while he was in the administration building in this arsenal area. And the strike that Mr. Keifer delivered was a knee into the thigh of Mr. Brooks. That is the extent of what Mr. Keifer had done to Mr. Brooks in that particular administration building. Judge, even taking a look at all the grand jury testimony, including the medical examiners, that knee to the thigh does not cause any injury, let alone cause any serious injury, and certainly does not rise to the complete reprehensible, immoral, evincing total depravity for human life. Just does not get to that level. From there, Your Honor, my client then says, enough. Everything stops. They then do not handcuff Mr. Brooks. 2 of the other COs begin to escort Mr. Brooks from the administration building into the area they call the man trap area. While in the man trap area, Judge, Mr. Brooks goes down to the ground. Now, you'll see if the court reviews the grand jury minutes, there's going to be some conflicting testimony. Did my client order them to put Mr. Brooks to the ground? Did Mr. Brooks throw himself to the ground? What is clear, Judge, is that when Mr. Brooks went down, according to Mr. Kessler, he is down on his chest and maybe to his side. So he's not laying on his back looking at the sky. He's looking more towards the ground or off to the side. At that point, Your Honor, acting alone, a one-on-one contact, Mr. Keifer applies a dose of pepper spray to Mr. Brooks. Again, Judge, the dose of pepper spray is something that is permissible under the policies of the DOC's directives, but there is absolutely no evidence whatsoever that the application of pepper spray caused any inability to breathe, difficulty in breathing, choking, or gagging. No injury, no grand jury testimony that there was any injury caused by the application of pepper spray. From there, Mr. Brooks was then lifted up, he was then handcuffed, and then he was escorted by two other COs. Granted that they're all there together, two other COs towards the infirmary. You see the two COs escorting Mr. Brooks as he's walking under his own power towards the infirmary. They get closer to the infirmary. Another CO picks up one of the legs or both legs of Mr. Brooks, causing his shoulder to drop, and then Mr. Kessler delivers two more blows into the ribs, thinking he's trying to struggle to get away, not realizing that another CO had picked up the legs of Mr. Brooks. During that transaction, Your Honor, my client is some 30, I don't know the exact distance because I haven't been there to measure it, but he's some 30, 40 paces behind Mr. Brooks and the two and now three COs carrying him into the emergency room. Behind the three COs escorting him in, there is a couple of sergeants. There's Mr. Gallagher that gets into his van and drives away. And then you see my client, actually he's the last person, and he's shaking a can of OC pepper spray as he's walking towards the infirmary. They get into the infirmary, Judge. My client is ordered out, okay? He does go in once or twice, does not contact Mr. Brooks at all. He then leaves. So with respect to the depraved indifference, Judge, we're really looking at two different incidents, one at the arsenal/administration building and one on the pepper spray. Even combined together, Judge, does not reach the level of depraved indifference to justify a murder-second depraved indifference charge. The lack of any intent to cause any injury, Your Honor. Again, the grand jury testimony is completely devoid of any evidence or testimony that Mr. Keifer sought to cause any injury, let alone a serious injury, to Mr. Brooks. I believe the manslaughter first charge, Judge, is not properly supported by the grand jury minutes. Then, Your Honor, we get to the gang assault. Again, Judge, the gang assault is looking for the causing of an injury or serious injury. And again, the grand jury testimony completely devoid. There is no injury or grand jury testimony. And that's also including all the reports from the medical examiner, Judge. The medical examiner does not say the strike to the thigh, the knee to the thigh in the administration building, the application of the pepper spray caused any injury. So I believe all those three charges must be dismissed, Your Honor. Judge, we'd also, and I'll briefly touch upon it, we also moved for a more particular and itemized bill of particular, who, what, where, when, how. Tell us what you're actually charging Mr. Keifer with. Where are you charging him? What is the action he did? Is he acting alone? Is he acting with others? We need to know all that to properly prepare for defense, and I'm asking that we get a more particularized bill of particular from the prosecution. Next, Judge, we're concerned about the videos. There's clearly 4 videos taken from 4 different body-worn cameras, no audio within that video. And there was a testimony by a Sean, I cannot pronounce the last name, so excuse me, Masau, something along those lines, who received 205 cameras, body-worn cameras from the facility. It was narrowed down to 4 particular body-worn cameras, and I believe that's all the snippets that they have are all contained in Exhibit 4, which was in the grand jury. But you take a look at that, and nothing was deleted from Mr. Sean Masau's analysis of these videos. They're then transferred over to law enforcement. Law enforcement then brings these cameras out to Axon, which is out in Arizona, and I forgot the name of the city that it's located in. There is, and we attach this as Exhibit B to our motion papers, there is I think it's an 18-page Axon report from what Axon had done with these particular body-worn cameras. And telling in there, and looking at that report, Judge, these 4 different cameras, some of them have up to 3.5 hours of recalled video. Others have up to almost 18 hours of recalled video. The video that we have received, Judge, is just an hour, maybe just shy of an hour. I have no idea where the other 2 up to 17 hours of video is. I do know that it was downloaded. I believe it was downloaded by Mr. Musso, if that's how you pronounce his name, as well as the Axon representatives. So, Judge, we would be seeking to make sure we get all these 18 hours worth of video so we can complete this investigation. Then, Your Honor, again, with respect to the duty to intervene, I would mimic much of the arguments that my colleague before me had argued that there is no statutory duty. While in the emergency room, my client was ordered out of the emergency room, he could not intervene. He's not present. He's down the hall doing paperwork. Duty to intervene at the administration building, he said enough. It stopped. Duty to intervene at the walkway, my client is the one that did apply the pepper spray. Nobody intervened at that point. There was no other force outside of the carrying in once the officer had lifted up the legs of Mr. Brooks when they actually carried him through the door of the informant into the treatment room. So in light of the deficiencies within the grand jury testimony, Your Honor, I would respectfully request that the murder second charge be dismissed, that the manslaughter first charge be dismissed, and that the gang assault charge be dismissed. Thank you.
Mr. Longretta, Mr. Hudson.
Thank you, Your Honor. I'm going to tackle those arguments kind of in reverse order. As far as the duty to intervene goes, I do understand where Mr. Longretta is coming from, that there is less import of the duty to intervene with Mr. Keifer than there is with others. Nonetheless, we will rely on our previous arguments to establish that for the things he did have an opportunity to intervene to prevent, he did have a duty to do so. As far as the videos go, every single second of the recall footage has been provided. That was provided specifically in, I believe it was the March 31st thumb drive. I'd be happy to help counsel walk through that and find that, but we need to be made aware that people are having trouble finding things before we can help them find them. Now, principally, the argument comes down to the factual basis for what Mr. Keifer did. And one thing that's worth keeping in mind here throughout is that the notion that Mr. Keifer actually did shout enough during the first portion of the attack in the Arsenal area is that that just comes from him. There are at least 3 other witnesses that were all present during the Arsenal attack, and not one of them said anything at all about Mr. Keifer stopping it. And there was varying testimony about how long that attack was, and we've all been in courtrooms before, we've all done trials. We know that time is very difficult to pin down when you're in the moment. Some witnesses said it was only a few seconds, some before the grand jury did say it was over a minute. Either way, we know that that attack included another co-defendant taking Mr. Brooks by the neck and lifting him off the ground. And this isn't a situation where there was one fatal blow or one critical moment. This was about 10 minutes of ongoing, non-stop conduct that Mr. Keifer, by his own admission, participated in. And similarly, the idea that he only threw one knee strike to Mr. Brooks' leg, that just comes from him too. Everybody else just described it as a swarm of people. So I think it's in error to downplay that, and I think the grand jury minutes will speak for themselves on that. I'm also not entirely sure I understand what Mr. Longretta was referring to by one-on-one contact when Mr. Keifer pepper sprayed Mr. Brooks. There were multiple corrections officers around, all of them present, and nobody said that Mr. Brooks was doing anything that warranted pepper spray. By all appearances and by all accounts, Mr. Keifer just took it upon himself for no reason other than because he could. We submit that that's evidence of the craven indifference. In addition to that, Mr. Longrad is correct. Mr. Keifer does appear to have been ordered out of the exam room, but before he was on his way in. And I don't mean into the room generally. He was already in the room. He was walking towards Mr. Brooks while he was being attacked before one of the other sergeants in the room can be seen on the video pointing at both him and another correction officer and gesturing, get out of the room. That's it. So this wasn't him deciding, oh no, I'm not going to be involved in this. He was fully on board by all appearances until he was sent out of the room. On top of that, worth considering in the entire totality of defendant's mental state here is what happened afterwards. And one of the counts in the indictment that Mr. Longrad doesn't mention is that this defendant is charged, and there's very strong evidence that with submitting a false use of force report to try to hide the initial portion of the attack in the arsenal, and certainly to make no mention of the attack in the emergency room. All of that speaks to the mind state that he approached this with, and that is a complete disregard for Mr. Brooks' humanity and his right to life. We submit, Your Honor, that all of that does establish deliberate, depraved indifference, and certainly intent to cause serious physical injury when he's part of multiple portions of this ongoing attack. In any case, although Mr. Longrad may have pointed out that there's no direct evidence of causation, he's charged with acting in concert. Given that he is responsible for what everybody else that he helped did and all of the consequences that they brought about. Your Honor, given that, we would submit that the grand jury minutes are sufficient. And while I have a window, though, I will provide the same thumb draft to defense counsel.
Acknowledge receipt, Your Honor, and now we'll put the bucket.
Okay, very good, thank you.
Yes. One last comment, or no? A lot of what Mr. Hudson respectfully is arguing, Judge, is all conclusory allegations, conclusory opinions of the prosecutor as to my client's conduct, my client's state of mind. I just wanted to point that out to the court when considering and reviewing all this. Thank you.
As to the defendant's motions relative to discovery, both sides are reminded of their respective obligations under the CPL and may involve the court if there is a genuine discovery dispute. However, the court will at this time direct and order both sides, as contemplated by Article 245, to confer with one another and resolve any discovery disputes before involving the court. As to the defendant's motion to preclude non-notice statements, that motion is denied at this time, but with leave to renew should the people seek to introduce such evidence in the future. The defendant's motion to suppress statements made to law enforcement is denied at this time. However, the court will grant the defendant's motion for a Huntley hearing concerning the voluntariness of such statements. The court will also grant the defendant's motion to review the grand jury minutes in this case. Those will be reviewed in camera for sufficiency, including the legal instructions given. As to the defendant's motion for sanctions relative to the body-worn cameras, the court will reserve decision at this time. Likewise, with respect to the motion for order to compel the prosecution to file a more responsive bill of particulars. As to the suppression hearing, Mr. Longaretta, my next available dates are July 15th or 18th.
Judge, I did look at my calendar, the 18th works best for me, if that's okay with Your Honor.
All right, then the 18th it is. That will be at 10:30 a.m. Mr. Keifer, that's when your next due back in this court, July 18th, 10:30 in the morning. We'll have your suppression hearing at that time. See you all back.
Thank you, Your Honor.
Kingsley.
This is the matter of the people against David Kingsley, indicted 25035. This matter was adjourned to today's date for argument and decision with respect to the defendant's omnibus motions. The court is in receipt of the written motions of the defense along with the people's written response. Did either side wish to be heard further? Mr. Mr. Mebush?
Your Honor, just briefly, concerning the motion for severance of the other co-defendants in this case, I believe the statements from my colleagues this morning, when they constantly mentioned the injury of Mr. Brooks and who caused that injury, would significantly prejudice Mr. Kingsley going to trial with these co-defendants. Again, as stated in my motion, they're trying to place the blame on the other people that were involved in this incident and pointing the finger at the correctional officers that were in the infirmary. I think that that is extremely prejudicial. I think it will tie our hands in many instances when it comes to correctional officers that are going to testify, the other co-defendants that may testify, the ability for Mr. Kingsley to testify. And with that, Your Honor, I would ask that Mr. Kingsley's case be severed from any and all co-defendants in this case. And other than that, Your Honor, I'll submit my written motions.
Mr. Hudson?
Thank you, Your Honor. It's one thing for everybody to be arguing that, oh, it was actually this person that did the most damage, it's this person at this stage. When we're talking about sufficiency of the grand jury and we're talking about whether people's actions are fairly attributable to others. It's another thing when we're at trial, they're all charged as acting in concert, at which point every time somebody tries to highlight somebody else's conduct, they're making themselves look worse. They're making their own case worse. We submit that there's no basis for severance, and it is a very high burden, especially in this case, as complicated as it is, as big of an investigation as it is, and with as complete of the overlap as there's going to be in terms of one case proving one case to the other. Trying this case 8 times would just not be feasible, especially not when there really is no showing of any significant prejudice that's going to undercut Mr. Kingsley's ability to put on his own defense.
Do you have materials you want to supply as well?
I do, Your Honor. Yeah.
Now we'll proceed.
Yes, Your Honor.
As to the defense motion for Sandoval and Benamiglia hearings, that motion is granted. Any such information must be turned over to the defense no later than 15 days before the first scheduled trial date. As to the defendant's motions relative to discovery, both sides are reminded of their respective obligations under the CPL and may involve the court if there is a genuine discovery dispute. As to the defendant's motion to suppress statements made to law enforcement, that motion is denied at this time. However, the court will grant the defendant's motion for a Huntley hearing concerning the voluntariness of such statements. The court will also grant the defendant's motion to review the grand jury minutes in this case. Those will be reviewed in camera for sufficiency, including the legal instructions given. The court will at this time reserve with respect to the defendant's motion for severance from his co-defendants. As for the Huntley hearing, Mr. Mebush, you're down to July 15th. Any issues with that date?
No, Your Honor.
July 15th at 10:30 a.m. Just for the information of the media and the public that have interest in this matter, the media and the public are welcome to be present for suppression hearings. However, the current state of the law does not permit audio, video recording, or still photography in any form. So I just want to alert you to that ahead of time. Mr. Kingsley, I'm going to have you back here now July 15th at 10:30 in the morning. We'll have your suppression hearing at that time, and then we can move on and talk about scheduling your trial. I'll see you all back here then.
Thank you, Your Honor.
That concludes these particular cases. If the meeting wants to take a moment, we'll take a short break.